Start. It is clear from the scheme of the Act as explained by this code in SBP and Company that in regard to issues falling under the second category, if raised in any application under Section 11 of the Act, the Chief Justice slash his designate may decide them if necessary by taking evidence. Alternatively, he may leave those issues open with a direction to the arbitral tribunal to decide the same. If the Chief Justice or his designate chooses to examine the issues and decides it, the arbitral tribunal cannot re examine the same issue. The Chief Justice slash his designate will, in choosing whether he will decide such issue or leave it to the arbitral tribunal, be guided by the object of the Act, that is, expediting the arbitration process with minimum judicial intervention. Where allegations of forgery, fabrication are made in regard to the document recording discharge of contract by full and final settlement, it would be appropriate if the Chief Justice slash his designate decide the issue. What is, however, clear is when a respondent contends that the dispute is not arbitrable on account of discharge of the contract under a settlement agreement or discharge voucher or no claim certificate, and the claimant contends that it was obtained by fraud, coercion, or undue influence. The issue will have to be decided either by the Chief Justice slash his designate in the proceedings under Section 11 of the Act or by the arbitral tribunal as directed by the order under Section 11 of the Act. A claim for arbitration cannot be rejected merely or solely on the ground that a settlement agreement or discharge voucher had been executed by the claimant if its validity is disputed by the claimant. The issues included in the first category were whether the party making the application had approached the appropriate high court, that is, the jurisdictional high court, whether there is an arbitration agreement, and whether the person who had applied under Section 11 is a party to such agreement. This would include the question whether the defendant or the opposite party is a party to the arbitration agreement or bound by the arbitration agreement in terms of Section 7 of the Arbitration Act. With respect to the second category, the court observed that the Chief Justice or his designate may decide the issue if necessary by taking evidence, or in the alternative may leave the issues open with the direction to the arbitral tribunal to decide the same. Where the Chief Justice or his designate examines the issue and decides it, the arbitral tribunal cannot re examine the issue. The Chief Justice or his designate would exercise this choice being guided by the object of the Arbitration Act, that is, expediting the arbitration process with minimum judicial intervention. Where dispute arises on account of settlement agreement, discharge voucher, no claim certificate amounting to discharge or accord, and satisfaction and the other side contends that such certificates were obtained by fraud, coercion, or undue influence. The issue will have to be decided either by the Chief Justice or his designate in proceedings under Section 11 or by the arbitral tribunal as directed by the order under Section 11 of the Act. A claim for arbitration cannot be rejected merely or solely on the ground that the settlement agreement or discharge voucher had been executed if its validity is disputed. The third category would cover all other questions within the arbitration clause which the court believed are within the exclusive jurisdiction of the arbitral tribunal at the first stage. This was explained by giving an example of a matter purportedly reserved for the final determination of the departmental authority or accepted or excluded matters. It would also include merits of any claim involved in arbitration. Para 22 of Bogra Polyfav Private Limited, if read carefully, states that the factors to be considered while deciding an application under Sections 8 and 11 of the Arbitration Act would require an examination of whether there exists an arbitration agreement, that is, the agreement provides for arbitration proceedings in respect of disputes which have arisen between the parties to the agreement. The latter portion requires the court to apply its mind whether the disputes which have arisen can be settled by the arbitration agreement. Stop.